So welcome to Quadcast, Quadrant Chambers discussion forum looking at news, hot topics, legal developments in the world of commercial litigation. We're four barristers from London, Quadrant Chambers in London. That is me, Paul Downs, Poonam Awani, Joe Sullivan and Claudia Wilmot-Smith. And we like to get together every week and talk about a topic. This week, we're going to look at the franked investment income case, and we want you to join in. So please send us messages either on the YouTube chat function or by email to quadcast@quadrantchambers.com. Last week, we had a tsunami. Normally, it's quite quiet, but we had a tsunami of comments and questions because we were looking at the changes to the CPR. And I think it's got some of you certainly a bit vexed. One question that came in after the programme, which I just mentioned, was why didn't the Rules Committee give a longer lead time so that people had more time to absorb? And I think the answer unattributably is, well, go and ask the Rules Committee. But anyway, this week...
Someone might have told us it wasn't the Working Committee's fault and that they weren't in charge.
Well, I wasn't going to go into any details about who was... Anyway.
Come on.
Enough of that. News. What's been happening? Poonam, what's your news?
I've really struggled to come up with news this week, guys. I think I've done normally pretty well in lockdown. So in desperation, all I can tell you is I am really quite happy because you may recall I have been in scaffolding for the last 8 weeks and it's all come down this week and I no longer feel like I'm in jail and I can see out my window. And
so there is something to counterbalance Nadal's tragic.
Okay, really, Claudia. So, can I leave this podcast now? I watched really late last night, and I was
just really worried about you. I was like, oh God, no, Nadal's loss is going to be her news. This is it. But
you don't watch tennis. He didn't just lose. He lost from being 2 sets to love up. Only the third time that's happened in his career. Okay, Aunt Joe, what's your news? Thanks, Claudia.
Well, I haven't been watching Rafael Nadal, but I'm pleased to hear. I've been out. I've left Highbury. I've been chambers because I've been doing a hearing in my leaders' chambers. So I've sort of gone blinking out into the real world and been to different places. It's weird, but nice. And that's the extent of my news because I've been doing this hearing. How about you, Claudia?
I mean, I also don't have any news. I haven't left my house for about 10 days. My sister's been able to ski out of her front door. My news is vicarious family news. My sister lives in Scotland and she can go cross-country skiing from her front door because the snow's so thick. I'm seethingly jealous and considering a move to Scotland. How about you, Paul?
Well, last week I mentioned the Handworth Parish Council meeting, and I don't know if you've all seen, it's back in the news again today. We've got a photograph from it, but they resumed their meeting I think yesterday on Zoom, and they had, well, the reports differ. One report I read said 80 people attending, another report was 4,000 people attending.
I did wonder whether you were one of them.
And no, I didn't. Another people attending. But the meeting descended into chaos as people were shouting, "You have no authority." Jackie Weaver would not allow this, and apparently at one stage there was some Benny Hill music played until somebody worked out how to mute all on the facility. Jackie Weaver wasn't there though, so there you are. But that was the most newsworthy thing I saw this week. Anyway, this week we are looking at franked investment income case, limitation, mistake of law, payments made under mistake of law. And remember, you can, that email again, quadcast@quadrantchambers.com, chat on the YouTube function if you've got questions or comments. We'd love to hear them. But anyway, look, Joe, what's the broad territory here we're hearing? What's the limitation point that we're concerned with?
Well, so the underlying provision is Section 32 of the Limitation Act, which provides for effectively the postponement of the start of the limitation period in certain circumstances. Three categories of case. So first, where the action is based on the fraud of the defendant. Secondly, where facts relevant to the cause of action are concealed from the claimant by the defendant. And thirdly, action for relief from the consequences of a mistake. And in each of those categories, limitation doesn't begin to run until the claimant either discovered or could, with reasonable diligence, have discovered the fraud, concealed fact, or the mistake.
Joe, Joe.
Yeah.
So with fraud, you're saying the people will be saying the defendant's a baddie because he's a fraudster. With fraudulent concealment, you're saying the defendant's a baddie because he's. With mistake, do you need that badness element? Do you need to say that the defendant has contributed to the mistake, or does it not matter how the mistakes arisen?
No. So just because under the old Act it was fraudulent concealment, now it's just deliberate concealment. Although actually, in practical terms, there may be very little difference between those two words. But no, you're quite right. So for mistake, the point here is not we will punish you, defendant, and allow a claim to be brought whenever because you're a bad guy. It's about meeting the preventing a policy, an inadvertent policy effect from limitation that shouldn't apply. So in a case of mistake, if you are mistaken, then ipso facto, you don't know about your claim, because if you did, you wouldn't be mistaken.
Is there a lacuna, though? Because if the touchstone is when could the claimant reasonably bring the claim, then surely any concealment should defer the limitation period, i.e. concealment by a third party, not the defendant.
Yeah, well, I think that's a policy balance. I mean, it doesn't, just to be clear, it doesn't have to be concealment by the defendant personally. It could be concealment by their agent or by someone.
No, but I meant just like a...
I take the point.
Yeah.
I guess if there's a fact that's being concealed that you don't know about, even if it's not because of the defendant, then you have a mistake. You're mistaken because you didn't know the facts. So would that be enough? The mistaken part has to be the cause of action. So it has to be the claim has to be relief from the consequences of a mistake. I think, Paul, your point is if it's a different cause of action like negligence, but a fact relevant to the cause of action has been concealed from you by someone else. Okay.
So you've got negligence has got its own sort of protection as well, hasn't it? With latent damage and the like. So
yeah.
So this is mistake of law, and for those of you who don't remember or haven't looked at it recently, the starting point is the case of Kleinwort Benson and Lincoln City Council in the late 90s. The background to it all is these swap transactions that various local authorities entered into, principally to raise money. It was a way of raising money that didn't appear on the balance sheet of the authority. And it was decided in Hazel that these swap transactions, because they were speculative, were ultra vires and so therefore void and unenforceable, both against the bank and against the local authority. Well, Kleinwort Benson had entered into a series of swaps with various local authorities in the 80s, and they had actually lost money on the swaps, not like the recent cases where the banks won, and they'd lost £800,000. Now, 300,000 of that was within the limitation period, but 400,000 pounds of it was more than 6 years before they launched the proceedings. And they wanted the money back. They claimed for the money back. And they argued that the limitation period should be extended because it was a mistake case. It was a mistake of law. They couldn't discover the law until Hazel had been decided. And so therefore they should get the full sum back. Went all the way to the House of Lords, 3-2 split. The minority, led by Lord Brown-Wilkinson, said there should be a remedy here, but because payments recoverable under a mistake of law could mean that when the House of Lords in those days declares that the previous state of the law was incorrectly viewed, that then is declaratory in nature and not changing the law, it's declaratory. That could upset transactions going back theoretically years and years if you apply Section 32. So the minority said, look, this is not the way to do this. It has to be done by Parliament. The majority, though, led by Lord Gough, said it can be done by the courts, that yes, you can recover under mistake of law, and yes, Section 32 does apply. And it's not a problem because logically, there's no logical problem here, because when the payment's made at that point in time, it might not be mistaken because of the state of the law. But when the declaratory judgment later says that the law was otherwise, that has retrospective effect. It changes the law retrospectively. So therefore, you sort of rewrite history and it becomes a mistake sort of after the event. So that was Kleinwort Benson. But I think next it's Deutsche Morgan Grenfell, isn't it, Poonam?
It is. And so wait, so Paul, I mean, when Section 32 was first enacted in the first Limitation Act earlier in the 1900s, there wasn't even a cause of action for mistake of law, was there? It was just mistake of fact.
And it was very well settled that you couldn't recover.
Quite.
Well, there wasn't a cause of action for mistake of law, and the statute also said, didn't it, that these relief from the applies to limitation as set out in this act. So it can only have been limitation periods that already existed, right?
Right. And the 1980 Act is codification. That's clear. It's not new legislation. So what you're saying is that in Kleinwort, they decided that the statute was giving relief for a cause of action that didn't actually exist when the statute was enacted.
Well, to be fair, the cause of action for money hadn't received, it was long-standing. It was just the scope of the cause of action,
right,
or the basis upon which you could mount what later became sort of unjust enrichment-based restitutionary remedy.
Okay, so then, as you say, next is Deutsche Morgan, which was heard by Miss Justice Park in 2003, reversed by the Court of Appeal in 2005, and then restored back to first instance by a 3-2 majority in the House of Lords in 2006. And what this case was all about was that the claimant said that they paid all this tax and they wanted to recover the tax they paid back because they said the money had been paid under a mistake of law because they thought they were liable to pay this tax. But in fact, because of a decision in 2001, they now knew that the law was wrong and that they were never under a liability to pay it. And the interesting thing about this, guys, is that the 2001 court that had said, yeah, the tax law was illegal, was they said that it was on the basis that it was incompatible, our tax laws, with EU laws. So that it all dated back to 1973, when we joined the EU, that all this incorrect tax payments had been made by lots of people, including the claimants. So they wanted to claim back all the way back to 73. Limitations, therefore, an issue. Therefore, they're saying, no, we're relying on Section 32 and mistake of law, da-da-da-da-da. So this took the position even further because it adopts Kleinwort's view about mistake of law is within Section 32. But what became key in this case, and the second element, is, well, so you can rely on Section 32. When is it under Section 32 that you knew or could with reasonable diligence have known your mistake? You could have known the true position about the law. And the majority hold that the time when you could with reasonable diligence have known about the mistake of law is only when the unappealable court changes the law or declares the law. So in the facts of that case in 2001. Makes sense to me. Yeah, here's the irony, and the facts there, and I think in fact investment, show you why it doesn't work, which is the claimants in Deutsche Morgan had actually issued their claim form before 2001. They had realised that this thing was, there were lots of grumbles about the legality of the tax laws and that it was going to be argued. So they issued their claim form. So what the House of Lords decided was, oh, you didn't know you had a cause of action until 2001 because that's when the court decided that the law was all wrong. But yeah, never mind that you actually started your action before then and you didn't even...
exactly. Yeah, same in the FII. They said, at the time I issued the claim form, I had no idea I'd made a mistake of law and I could not possibly have known.
But I knew that I made a mistake of law when I did that.
But, I mean, people issue bad claims all the time. I do kind of see Hoffman's point that...
Well, isn't it? I think that's very different. If you've got a tax statute and an incompatible EU statute, the tension and incompatibility is there for all to comment on, academic writers, practitioners, everybody there. It's very different when if you've got an established, settled Supreme Court decision and people are speculating whether if it comes up the next time, the Supreme Court will change the law. But anyway, that's Deutsche. Claudia, just looking at my running order.
No.
Claudia, tell us about franked investment. You're the franked investment income expert, aren't you?
Well, I don't know about the expert, but yeah, I mean, so there was the same tension. They issued their claim again for payments of advanced corporation tax, which they've been paying since the 70s. saying we made these payments by mistake because they are, we had thought that this tax regime was enforceable. Actually, it was contrary to EU law. Then the same claimants got to the Court of Justice of the EU and established that the UK tax regime was contrary to EU law. So said, see, we pay by mistake. We want our relief from the consequence of the mistake. And the same argument that they've made in Deutsche Morgan, Pudam's point, we could not reasonably have discovered the consequences of the mistake because applying the test in Deutsche Morgan until a final court decision providing for the mistake. So they said until the EU court, which was the final court, issued the decision, then applying that same line of reasoning, that was the first date we could have discovered our mistake. And so they said that they had a case. HMRC said, well, first they made the point that Pudam referred to earlier, right, about Section 32(1)(c not applying to mistake of law. Because, sorry, it's the Kleinwort Benson case that Paul talked about and Pudam talked about the arguments. So there was that argument, but they said if that Section 32(1)(c does apply, the mistake of law is discoverable on the very date the payment is made, right?
Wait. So Paul's talking about how we don't have lots of law changing all the time. I think what you're saying is that in Frank investment, HMRC were arguing that Kleinwort Benson was wrong and should be overruled, and was arguing that Deutsche Morgan was wrong and should be overruled.
Once you get up to the Supreme Court, I mean, why not? Go for broke. That's what I say.
And how did it go?
There was a preliminary, there's a point that we're not really dealing with about abusive process and res judicata, whether this point could even be argued. The court held unanimously that it could. But then on the question of the Kleinwort Benson question, does that Section 32 apply to mistakes of law at all? The majority said, yes, it does. That's Lords Reid, Hodge, Lloyd-Jones, Hamblin and Carnworth. They held that although obviously when the section was originally brought into force, it can't have been intended to apply to claims for relief from mistakes of law because that cause of action didn't exist. When you just read the language of the section, it has to apply as a matter of construction because it applies to mistakes, and a mistake of law is a type of mistake. But also for the policy behind the provision, it should apply, because why should a claimant who has made a mistake of law and made a payment under a mistake of law not be able to get their money back? Why should they be stopped from limitation when they could never have reasonably been expected to bring their claim sooner? So that was the majority on that point. The minority, Lords Briggs and Sales, disagreed. They would have overruled Kleinwort Benson.
Hang on, I'm not sure whether we've made this clear before. You've named so many names. That means it's a 7-person tribunal here, right?
7, yeah. So yeah. 5-2 split on this point. And they made a lot of the
Hamlin, Briggs, Sales.
Very good, Claudia.
Briggs, Hamlin, Carnworth, 5.
Yeah, so the minority was Briggs and Sales.
Correct.
And another one, or was it? Yeah.
Yeah. What did they say, Joe? I was on the edge of my seat.
So, yeah, I've definitely said 7 names. I promise you. What
did the minority say?
The minority said they would overrule Kleinwort Benson, and that was largely on policy grounds because otherwise you're bound to reopen loads of old claims. This goes beyond the narrow principle that Section 32 was intended to address, and it undermines legal certainty. Now, on the discoverability question, they all agreed, albeit that the minority said this shouldn't arise at all. But they said if we're wrong about that, and the majority said we're right about that, then on discoverability, Deutsche Morgan Grenfell was wrongly decided. And so it's not, you don't have to wait until your claim for mistake of law is decided.
But they didn't accept the extreme position the other way, right? Which is that you should discover the mistake on the date you make the payment.
Correct.
Which kind of follows from the nature of the action. So they accepted the minority position in Deutsche Morgan.
That's correct. So they held that that you know, as soon as you know enough in the sense that you have a worthwhile claim, then time starts to run.
So I'm saying I make this payment by mistake. And if I am mistaken, I can't say the law has changed so as to render me mistaken, but they do say that the law changes.
Well, they say that the law has been. You were wrong.
Like
about
I'm
what
deemed
law
to make a
was.
mistake.
Yeah, you were wrong about what the
thing
law
is
was.
that even when judges accept the law changes, they also will steadfastly assert that it changes retrospectively. So that's the effect of the declaratory theory.
Yes.
So it's not you change the law, but it has retrospective effect, obviously.
Yeah.
Because we'll get in a terrible mess otherwise.
Sure, but does that mean that I made a mistake at the time? Because if it's only changed retrospectively, I think there's a sense in which I can't say I've made a mistake.
Yes, but and that was one of the arguments as well, but they said, let's get real here. Although we have this declaratory idea and we say the law was always this way, even though we've only now overruled some cases, when you come to section 32(1)(b), they recognise that when you made the payment there, you made the payment because there was a mistake as to what the law in fact was at that time.
And of course, here they were dealing with the limitation problem, but Claudia, your point goes to the existence of the cause of action itself, doesn't it?
Yes,
So
and I'm not sure they really dealt with that point satisfactorily. But yes, sorry, carry on.
Well, I was just going to conclude by saying, having said it's all about when you could have brought a worthwhile claim, they then said, but we're not going to decide when that actually was. We're going to let a High Court judge
It's all a matter of evidence, right? You need experts to say, because Lord Reed's got this idea that there's this body of law out there which is developed partly through judicial decision making, but also academics writing articles, practitioners sort of sitting in their towers and with a cold towel over their head and developing this idea. And at some point it will evolve and you can then tap into it. And so there are these two questions on which you need evidence. When has the law changed, evolved to accept this new point? And then two, when could the claimant reasonably have accessed that new opinion? Because it's not when a judge says it, right?
Yeah, so
that's quite a difficult evidential point, I think, which they batted back down.
Yeah.
Well, fine.
So my question is to you all: is Kleinwort Benson more trouble than it's worth? Poonam.
Yeah, I'm with the minority. I get the principled idea that, well, if it's a mistake, it's a mistake, it should be penalised. That's why I asked Joe right at the beginning, is it about the defendant being a baddie or the claimant being in a tough spot? And he's as much in a tough spot, even more so where it's a mistake of law when it's because the law's changed and things have developed. But from a principled sort of policy, not having stale claims forever position, I have real problems with mistake of law being allowed under Section 32. Now, history lesson. I mean, I asked Claudia, did they argue in the Supreme Court? Because Claudia's brother was one of the barristers, if we haven't mentioned that.
Well, can we just, before, I'll let you make that point, but before that, never mind Section 32, is mistake of law as a basis for restitution itself a bad idea?
No.
Because you can't say the law changed, so you can't say you made a mistake.
On the basis of commercial certainty. And then we'll talk about...
So what do you mean by on the basis of commercial certainty?
Well, because the whole idea that you say I've made a payment on a mistake of law is allowing changes in the law to unwind things, and why allow that if you want commercial certainty? The law is the law, as it's understood at the time, and you shouldn't be allowed to unwind it. That's Paul's point.
So what do you, Joe, what do you think? Would you maintain the rule?
Yeah, I would continue to allow. I don't see why, if you make a payment under a mistake of law, you're equally disadvantaged as if you make a payment under a mistake of fact. And there are consequences to the commercial certainty, certainly as between the parties to a mistake of fact, just as there is an issue of certainty, uncertainty, or certainty in connection with a mistake of law.
But you could apply that argument to the injustice of the House of Lords getting it wrong in a case. That injustice extends to those parties, and then all the other first instance and Court of Appeal decisions that decide on the basis of the House of Lords. Why should you go further then and say, well, commercial transactions on that basis, when the House of Lords later changed their mind, Supreme Court, those parties who suffered because the first House of Lords got it wrong, they're in a special category. Their injustice should be reversed. Just seems to me to be part and parcel of the way that the common law works.
No, well, I think if you decide that it is unjust, the answer is not to say, let's rule this out so that all cases are dealt with unjustly.
Right.
Can't get
The limitation is a policy decision. What you're saying is, well, if we allow it to the parties in one deal, why aren't we allowing it to everyone? So we shouldn't allow limitation to stop everybody else from relying on it.
Well, I see that. I mean, I just think we're going down the wrong path here. I mean, you can't appeal out of time, can you? If there's a change in the law, you can't say, oh, well, 10 years ago I lost before the county court. Now the House of Supreme Court's decided that the law is otherwise.
No, you're right. You can't.
So
and what's changed?
What's the difference?
Well, what's changed? You're right. And so this only gives relief, having this mistake of law where you've made payment so that you are now the claimant in a new action. You can't unwind everything because of a mistake of law, but you can, by virtue of the doctrine of restitutionary remedies, unwind where you've made a payment. But the fact that you can't allow limitation to be the driver, Paul. Either there should be mistake of law or not as a matter of commercial certainty. But even if you allow it for that, that doesn't mean you then, in fairness, have to allow it for absolutely everybody going back for stale cases.
I'm with Lord Brown-Wilkinson in Kleinwort. I think that was absolutely bang on. It's too difficult. But anyway, I've made my point. I interrupted you, Poonam. Section 32.
Am I supposed to remember what I was talking about?
I think you were going to talk about. You could have.
I know what I'm going to talk about.
130 years.
Oh, that's what I said. That's where I was. Thank you, Paul. So I asked Claudia to ask her brother whether they'd done some sort of analysis in the Supreme Court, one side or the other, about how many times the Supreme Court has overruled cases and how many times settled laws have been all changed. And Claudia didn't give me an answer. I don't know whether her brother didn't reply or whatever. I know you did, but I'm not going to. Anyway, however, there is a really good bit in the dissenting judgment. Where they point out that 2 years ago, 2018, there was a Supreme Court decision in Rock Advertising. And all of you will remember that was about.
Yep.
It was about non-reliance clauses, entire agreement clauses. But along the way, Lord Sumption et al. Were asked to overrule Folkes and Bear. And everybody listening who's ever read law remembers Folkes and Bear because it's one of those silly cases we learned about in our studies. And to remind you all, it's the ruling that where you're owed money and you do a sort of settlement to arrange to take part of your debt or installments, that deal is unenforceable by the payer, the person who owns money, because they haven't got consideration, because part payment of the debt isn't good consideration. Anyway, that's Folkes and Bear. And in Rock Advertising, the Supreme Court were asked to overrule it. They decided not to go look at it because it became irrelevant given their decisions. But Lord Sumption said, it is ripe for reconsideration, but we let another Supreme Court decide it. I know what you're thinking, Claudia. Hold on. And what the minority said in Frank's investment was, just look at that. If Lord Sumption had overruled Folkes and Bear, which he clearly really quite wanted to, then he would have changed long settled law that's been 132 years, and people who'd made payments thinking that they couldn't defend on the basis of, couldn't resist paying, could now reclaim what they paid as being paid under a mistake of law right up until 6 years after Lord Sumption and Rock Advertising, i.e. until 2024. So you could recover claims from 138 years ago.
That's never going to happen though, Poonam, is it? Because in almost all of those really old cases, there'll be a change of position defence.
Okay, maybe 134 years being a bit dramatic, but 20 years, 30 years, and maybe there will be a change of position. Maybe they won't be able to find out paperwork to prove a change of position.
Change of position is very hard because even if you've given the money away to charity, unless it enforces on you some real hardship to repay the money.
You clearly don't live a lavish enough lifestyle, Paul.
It's got to be changed.
That you spent it all on whiskey and donuts. Then
being inequitable doesn't mean hardship. That's not
well.
right.
You look at the case; they're very, very difficult to change of position. Defence off the ground. The restitution.
But when do people start saying Folkes and Bear is wrong?
Well, I'm issuing my
because it's right.
writ.
So we know now that Lord Sumption thinks it's right for reconsideration. So I think arguably you've got, you satisfy this writ test, right? This minority DMG test, which is now the test. Did you satisfy it before it? Like, at what point did that law evolve? I think possibly at the latest, the rock advertising, but possibly earlier. I don't know. I'm just thinking all of these claimants that you're talking about might need to start to get issuing.
Yeah, issue there is.
They can't wait until the law has been decided.
The other problem I've got with this is that it's very difficult to draw the line as to what's reasonably discoverable, because it's not just a binary question. There's this whole range. At one end of the spectrum, you've got a settled House of Lords,
right, and
been around for 50 years. Nobody would question it. Suddenly it's overturned. On the other end of the spectrum, you've got a first instance decision, which everybody thinks is crazy. And there's been a lot of articles about saying the minute that same point goes up to an appellate court, they'll reverse it. And in between those two extremes, you've got this just an infinite number of nuanced possibilities.
So, but yeah, so
where's the judge begin to
now?
Decide? And another thing, what is reasonably discoverable? I mean, is it reasonable to expect somebody to go to the high street solicitor and ask for advice on something? In which case, the solicitor may very well just open the most recent textbook.
Okay, all right, hold on. So if mistake of law is in 32, all your points would suggest mistake of law shouldn't be in 32. But if mistake of law is there, what would the test be? I mean, it can't be the date of judgment, which is what Deutsche Morgan held, where we're all saying, what does reasonably discoverable mean now? But what alternative is there?
I think it's the date of judgment. Anyway, let's move on and talk about the episodes we've got coming up. Next week, we're going to take a break, everybody. So there'll be no Quadcast next week. But the week after that, that is the 4th of March, we're going to look at exceptions to the without prejudice rule. The recent case in the Court of Appeal, Motorola and Hytera, in which I actually had a peripheral involvement at an earlier stage. And it revisits this question because I don't know if you remember the Unilever exceptions. There's been quite a lot of sort of movement around those. And so we're going to look at that, where do the exact exceptions to without prejudice privilege lie. And then the week after that, that's the 11th of March, we're going to look at bankers' liability for third-party fraud, which is an interesting topic. Recent case, Philip and Barclays, where the first instance judge decided that the quince care duty does not apply to an individual, which I think must be wrong. But we'll look at that. And then the week after that, that's the 18th of March, that'll be the final Quadcast of this season. We haven't decided the topic. You can send us in your suggestions. And if we pick your suggestion, we will send you, or I will send you, a bottle of champagne to thank you for your ideas. So please.
Does that mean you get the right to decide which one we go with? I'm not agreeing with that.
Does that include our suggestions? Can we win champagne for doing our jobs?
No, it's got to be a viewer suggestion.
It's got to be a viewer, fair
but it'll be complete transparency. So the one thing, if you're watching this, the one thing that this team would like to see is me have to shell out for another bottle of champagne. So you will be represented 3-1 against my attempts to choose a different topic.
Producer Ben asks if he can take part, Paul.
Anybody can take part.
Okay.
Now, throwing me off my stride there. Subscribe. If you're not subscribing to the YouTube channel, the Quadrant Chambers YouTube channel, you need to subscribe now. If you're watching on YouTube and you're signing, just hit that subscribe button. We'll notify you. It's not just Quadcast, there are all sorts of other programs that go out, webinars and the like, and you'll get notice of all of those. That leaves it just for me to say thank you to the team. Thank you to Emily Saunderson, our long-suffering producer. Thank you to Ben Jacobs, our FII Productions, providing the live streaming services. Other than that, see you next week. See you in 2 weeks. Good afternoon.